Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi, everyone. Welcome to this episode of the Immigration Lawyers Podcast. This is a great episode that I'm going to do. It's an interview with Jonathan Wasden. I've been looking forward to doing this interview for a while now, since last summer, really. And it's really important because Jonathan is a specialist and has been focused and has this history of work in federal litigation in the immigration field. And that's something that's really important in the things we have to deal with nowadays as immigration attorneys. So I thought it was really important to talk with him about what's involved in the work he does, how people could connect with them to take their case to the next level. Because a lot of us are getting denials and RFEs or just straight garbage from the service, USCIS, that needs to be litigated to get a proper answer and proper adjudication of these things, especially to make it public so it's known that these errors exist. So we're just going to jump into it. Jonathan, thanks for joining me.
Thanks for having me.
Sure. Why don't we just start out with your background? I think that's an important part for people to know where you're coming from with this stuff. Could you go over your history?
Yeah, sure. So I initially started my legal career as a JAG in the military, and I did 6 years in a variety of places. And then my last assignment was stationed actually out of the Pentagon doing Guantanamo Bay cases.
Wow.
And so I had this crazy high security clearance that when I really got sick of doing the Guantanamo Bay cases, I left and went to DOJ because they were standing up a new office, the district court litigation section for immigration cases, and they anticipated a massive influx of terrorism-related immigration cases in district court, which never panned out. Uh-huh. So there's me and like 4 or 5 other JAGs who were all in the same kind of boat that were hired for the same reason, who ended up, doing different aspects of immigration law, and I ended up just getting into employment-based.
What year was this?
It would have been around 2007.
Okay, so you went to the economic-based or business-based immigration. So tell me more about what kind of work and cases you deal with then.
So anything that comes into federal court, when you're looking at challenges to either unlawful delays or looking at challenges to denied agency decisions, or when people do a facial challenge to a regulation or a rule, all of that kind of stuff would come into our office. And we would defend, at the time, we defended every immigration case in district court around the country. With the current law, with the current situation of law going on right now, they are so overwhelmed with litigation that oil proper, main justice in D.C., is really scaling back on what type of cases that they're handling. The U.S. attorney cases are now handling everything. But so I used to go out to L.A., Seattle, San Francisco, and Houston was most of my route back when I was at the Justice Department.
Could you talk more about that difference between DOJ's oil section and the district ADA's doing stuff?
Yeah. So you have main justice, which has just about every different statute that there is assigned to one component of main justice. So immigration cases go to oil, Office of Immigration Litigation. Both the removal side goes to the appellate section, and then the district court actions are all handled by DCS. And so they handle the things that are most likely to have an impact on national level policy. So if you make a facial challenge to a regulation, the legality of a regulation or a policy memo, oil's going to handle it. Mm-hmm. A class action case, oil's going to handle it. If it's something that is like a new big issue that looks like it's going to have a massive impact on the entire agency, then oil will handle it.
I see.
Otherwise, it tends to get handled by the local U.S. attorney's offices.
Okay, so you're with oil, and then how long were you there?
I think I was there 3 or so years, and then I went to the Office of the USCIS's AAO, the Appeals Adjudication Office.
Oh, interesting. Could you go into as much detail as possible how those process behind the scenes?
Yeah, so with the AAO, if you win your case, right, you can show complete and utter error, screw up, whatever, at the district level, or the district director or the service center level. Your case doesn't stop there. If you show that they're completely wrong, then what they do is, the supervisor, the adjudicator that went over that initial decision, pull it apart with a fine tooth comb and look for any conceivable minor technicality or any additional reason why they can deny the petition.
Mm-hmm.
And only after that, if you have crossed every T, dotted every I, will they approve your visa. I've seen some of the things just kind of like made me want to scream was, they'll go through and yes, you proved that the service center screwed up. However, there's no phone number on this experience letter, and that's a violation of the regs. So we're going to deny your visa for that. It's just really, really hyper technical, kind of crazy things like that that just seem like it's not worth going to the AAO because the service center director, the service center decisions are typically so bad, especially anymore. You're far better off taking a really horrible decision into federal court than an AAO decision where they've had oodles and oodles and time to really hone their decision and go through the evidence in the record and make it bad for you.
So you are permitted to go straight to district court instead of having to do all your different methods of trying to fix it up as AAO. So you could skip the AAO and go to district level court.
Yeah, you can, which saves you a lot of time. What makes a difference for exhaustion is if the regulation says you have to appeal, mm-hmm. and if while the appeal is pending, you get the benefits that you had requested, then you have mandatory appellate processes. If those two things don't occur, then you don't have to exhaust your administrative remedies. So in this situation, the AAO doesn't grant you whatever visa that you have requested while the case is pending at the AAO, and there's no requirement for you under the regulations to go to the AAO. So it's not a mandatory appeal.
Now, who are the people in the AAO? Are they like internal adjudicators there, or are they just attorneys like yourself that are assigned to review these?
Most of the people that work there, I would say, are probably attorneys. Some of them had prior agency experience. Some of them didn't. Some of them brand new to immigration law while they're doing this. Some of them are longtime employees that have been doing it at the service center level. Mm-hmm. It's kind of a mixed bag.
And sometimes, we get these decisions that are considered, what are the terms, the proper term for it, but precedent decisions come out of the AAO. And sometimes they're kind of nice. I'm surprised that they come out with things that are helpful. Is it just a mixed bag of people that work there? Some are more attuned and some just don't care or more harsh?
Actually, nothing comes out of the AAO that hasn't been blessed by the Office of Policy and Strategy.
Interesting.
So they fall directly underneath them. So any decision, precedent, non-precedent, has to be in line with what current agency policy is. So when people think they're going to an independent appeals adjudicator, no, not so much. They're on a stick diagram directly below eventually the director of CIS, and they take their marching orders just like everybody else in the agency, and they're not independent at all.
So what happened after the AAO? So you were there how many years?
God, you're making me do public math.
A couple of years.
6 or 7 years.
Oh, wow. More than a couple. Yeah. Okay, so you know the ins and outs. You've been dealing with this stuff for a decade at least. And then from that side of it, and then what happened after the AAO?
So I kind of hit my maximum fun level that I had with the government. So I ended up, I'm still in the reserve. So I did a year-long reserve tour in the
military. Which branch of the military?
Air Force. Yeah. So I did a year-long tour, and then around about November of 2017, I resigned from the government and just went into private practice.
Mm-hmm. And how has that been starting up a private practice?
It's, everything is timing, and location, right? So my niche that I've carved out is very useful right now, and there's not a lot of people doing it, and the timing was great. So, yeah, private practice has been incredibly busy. It's waking up at 5, working all day long until 7 o'clock at night, and still not having enough time to get all the work done. So,
So do you do the work primarily yourself, or do you have staff, or how does your system work?
I've got a paralegal that does a lot of work, and I also partner with a couple of folks that are attorneys that we work together on a lot of cases,
Hmm.
and so use some of their administrative staff as well.
That's great. So what are the stuff that's on your plate currently?
Oh, so quite a bit. A lot of the work obviously is H-1B related because that's the target that the
Hmm.
agency's got right now. In their dark little hearts, they would love to kill the H-1B program, especially if you're from India. But we're taking on the employer-employee relationship line of cases from the agency. We're taking on their requirement that you have to show a specific non-speculative work assignment for the entire duration of the H-1B visa when you file, and then also taking on the legality of the agency taking discretion to pick how long they're going to give you a visa for.
Hmm. Let's talk about that. Was an issue. They're assigning I-94s for like 2 days or some ridiculous stuff like that.
Yeah, yeah, I've seen them like, and they're post dated too, so you'll get your approval notice when it's already expired.
Yeah.
Especially for a cap case with consular processing, giving you a 1 day approval, like you're really going to make it through consular processing, get your visa stamp, hop on a plane, and show up in a 24-hour period. There's just something about that that strikes everybody as being just patently unreasonable.
It's pretty much bad faith.
Yeah.
Is that an argument of?
Well, part of the argument is that they're unlawfully trying to increase the amount of fees that they're receiving
Mhm.
by, if they can force you to file a whole bunch of extension petitions a year, then they increase their revenue substantially, right?
Hmm.
So if you have to file, you just pay like $3,000 in filing fees, and you have to file new filing fees immediately upon getting your approval notice. There's something about that that just smacks people as being wrong, and that's part of the argument.
Another great piece of work that you did is the lawsuit about the change in offsite work, especially for I think STEM employees. Could you discuss what you did there and the success you had?
Yeah, so for those that aren't aware of it, this USCIS on their website came out without telling anybody. There was no notice, there was no press release. They just came up and said, "Hey, you can no longer work for a IT consulting company, at an offsite location if you are on STEM OPT, and it's a violation of your student status if you do so." And it was applied retroactively. It wasn't in the regulation. There's nothing in the regulation that supports that, and it wasn't even acknowledged by the agency for a couple of months. And when some DSO was looking through the website and saw that, contacted, I think it was NAFSA, which is the trade organization for colleges and universities that do this. And all of a sudden, alarm bells went off, and everybody started freaking out that they might have a massive, huge status
Yeah.
violation problem. And then things started getting denied. And so the way that it was written was just so explicit and so non-discretionary. It was, you cannot do this, you must do this, or you will get a denial or a revocation or be in violation. And the language was so strong, and the way it was being applied made it pretty clear that this was essentially a regulation that they created without going through the proper process. So we went into court, we filed a preliminary injunction, and the day before the agency had to respond to our preliminary injunction motion, they changed their website back and eliminated all of the offending material. And then in their brief, did not acknowledge the fact that the prior version was there. The offending version that we complained about in our case, they completely acted like was not there and didn't even acknowledge it. Well, luckily we had screenshots that we used as exhibits when we filed the complaint. But it was just hilarious that they were putting their heads in the sand on it. They knew their position was so bad they just couldn't defend it, so they just said our position is what's on the website now, and that's legal and that's lawful, and didn't discuss what happened before.
Could a judge issue sanctions or something like that for this kind of behavior?
So the judge isn't typically going to issue sanctions against a Justice Department attorney unless, they've personally done something horrible in a case.
Hmm.
Now, against the agency, if the agency were to defend that and go, to the mattresses, to use a Godfather phrase, on that issue, then they would probably get EJA fees because the agency would not have been reasonable in their defense of the case and the issue.
Because it's so unfair. It costs so much money to defend these things just for them to on a switch change the website and they put through hell. And I had like cases that were related to this, and my clients were freaking out. It took so many hours of calling me and just to calm them down, and so it costs a lot of people money for them to on a whim just change rules and change it back like this. I wish there was some. I'm not familiar with federal litigation and stuff. Some bad faith lawsuits you could put on the.
Well, that part of what bad faith would be great, but the other issue is that the vast majority of the cases that I filed on some of these issues that I think are winners.
Mm-hmm.
You file the case, and before the government even answers, they reverse their decision, send out approval notices, so you never get a decision. So what they're really doing is they're acknowledging that they're violating the law. They're, approving for those cases that make it to litigation, just so they can continue to violate the law.
Yeah.
Right. Yeah. So they're not defending their cases. They're not defending their decisions and their analysis. They're banking on the fact that they can roll over in litigation fast enough that no judge will ever see what they're doing. And the vast majority of the people are not going to sue, are not going to go into court. And so it's a very low cost option for them to change the way things happen and to penalize the H-1B program without really getting a bad decision in court.
And you have a strategy to force their hand on this. Is that correct with the recent lawsuit?
Yeah. So because of this scenario was so common, you'd file and it would get approved like clockwork. The government has 60 days to answer the complaint in federal court. And sometime between day 1 and day 60, these were getting approved. So the issue becomes how do you prove to a court that this is a problem that is capable of repetition yet evading review? And that is what lets a court enter a ruling and a decision on a moot case, a case that isn't still alive. So when the government approves the petition, they moot it out. So the question becomes how do you drive that point home to the court so they will see the issue and continue to adjudicate it to prevent future abuses going forward. So we've filed 40 cases in a week and said, okay, there's 40 cases. They all looked very, very similar. And as soon as we did that, we got a notice from the court saying, we need to talk. Everybody get together. Let's talk. How we're going to handle, this massive number of H-1B cases that are alleging the same basic violations. So we ended up consolidating all of those cases into, for lack of a better word, a mini class action case in the District of Columbia. And we're litigating those three main issues, which is employer-employee relationship, the specific non-speculative work assignment requirement, and also the ability to shorten the approval period that's requested on the H-1. So that is in litigation right now, and our opening brief on that is being filed shortly.
Okay, I'm glad you brought that up. So could you go through the process of what federal litigation entails starting from getting the denial letter, and then let's say I'm an attorney, I get a denial letter, I do federal litigation, so I contact you. What do you do from there with the client for the case?
So a lot of that depends on a couple of different factors. One is the person going to lose status immediately? Are they, somebody who's been here for a while on visas and they have a reliance interest, they have a home, they have a family, and if they lose status, they're going to suffer irreparable harm. Then you're looking at a situation where you have to file the complaint with a motion for preliminary injunction right away, which is really, really labor intensive and time consuming. Mm-hmm. But this easy, typical case starts off with a complaint, and you serve the complaint, and then 60 days later, the government responds. And then when the government responds, you can do one of two things. You can wait for them to provide the administrative record, and then wait for the judge to issue a scheduling order that says when the parties will brief the issues for summary judgment. Or you can file your copy of the administrative record, because in employment-based cases, you have the entire administrative record as the attorney who filed the petition. You can file your own copy with a motion for summary judgment after they answer and say, here's our separate index, here's our arguments, and that triggers your briefing schedule on day 60, which is, in my opinion, is the better way to go, because the government will be caught off guard and will not have the time that they're normally accustomed to having to brief these cases. It's usually a very leisurely process for them. They'll provide the record sometimes 30 days after answer, wait another 30 days for a scheduling order to come out. First brief's going to be, 30 days from that, and it allows them to kind of pad their schedule. But if you take away that flexibility from them, you increase your chances of settlement with them approving the visa, or increase your chances of success because they just don't have time to really address the issues as well.
And if they decide to fight it out, how does it go from there?
Then you file your motion for summary judgment. They will file an opposition or a cross motion for summary judgment. Then both sides get a reply brief to each other. And then the judge makes a decision. Some judges have oral argument, some judges don't. It just really depends on the judge that you're in front of.
And you're in the District of Columbia and Virginia, so you could just directly file a case over there, or does it have to be where the petitioner or beneficiary is? How does that work?
So venue can be in D.C. because the government's headquartered there, which all they do all day long is Administrative Procedure Act cases, which is what these are. So it's, in my opinion, it's a good place to file because the judges get it. When you go out to some of the other places in the country where they don't get a lot of APA litigation, you can get some really squirrely results from the court. So I like being in DC for that reason. But you can file where the company's located at. You can file where the service center is located at, or anything that has a substantial nexus to the case.
Well, that's good to know. So you're swamped definitely with the amount of litigation you're taking part in. And what is this? You talked about the stuff you're working on right now, but what are the plans for? One aspect is your firm. Which direction are you going on this kind of stuff, and which direction do you see this litigation stuff going? Because if they're getting this number of lawsuits coming in, and the government, at least the courts, are seeing this kind of behavior, do you see any changes happening? I guess there was a lot of questions in there, but
I think the courts are going to get involved when they see government abuse, and I think the agency has given us a gift in a lot of ways. Is with the H-1B program, again, processing times last year, there's still cap cases that haven't been adjudicated, and people are having to refile a cap petition for somebody that still has a live cap from last year. And it's just inexcusable. There's just no explanation. The statute says they should do this in 30 days, and they've taken a year. There's a fundamental, undeniable problem. And then when you start seeing the denial rates skyrocketing, especially for certain types of business models, there's a problem. So the decisions are just crap for the most part. The quality of the decision is just awful that's coming out of the service centers. All of those things together point towards there is something horribly, horribly broken, and nobody's following the law. And that's when the courts are most likely to get involved and take a really, really deep, hard look at what's happening.
Very interesting. So thanks for joining us. I was really wanted people to hear the stuff you have to say and to, frankly, not be afraid to get involved in federal litigation. I know clients sometimes are when they're coming from foreign countries or they don't want to rock the boat. And that's an important point. Is it a thing that they should worry about? Is rocking the boat create more difficulties? Suing the government to some people seems like a dangerous thing. What is your opinion on that?
So in my experience, having worked in the government, people who were litigious and sued the agency always got treated better. And the reason was the agency hates to get sued. If they lose an issue, let's just say they lose employer-employee relationship in the H-1B program. That's 25% of their entire decisions, denial decisions, are now gone. They have to find a new reason to deny your cases, right?
Mm-hmm.
It's an agency that runs off of templates. So if you make one of their template decisions vulnerable or legal issues vulnerable, they'll freak out. So the people that are most litigious and go into court often, you know, they will get better treatment. I used to joke and call it litigation deference because there's Chevron deference. The government is given deference to interpreting a statute and creating a reg. There's our deference, which is the government's given deference to interpret their own reg. And then there's litigation deference, which is the deference the agency gives you when you sue them a lot. It's a totally better level of treatment.
Now, we talked about the H-1B context, but have you done or seen lawsuits happening? One is an L-1 context, and also with consular processing and the embassies kind of making up their own rules when it comes to business cases.
Yeah, so I see a lot of issues with L's. I've had several L cases, and also, the immigrant visa analog to that. And for some reason, the more complex your business model, the more inclined the agency is to get confused and just say, enter a fraud finding. Mm. So I've had a lot of litigation on the fraud finding issue, challenging the legality of fraud findings, the way they're doing it, the procedure they're using for it, and just the underlying arbitrary, capricious nature of the decision finding fraud. So I think that's probably some of the bigger issues right now with that particular line of cases. And then other immigrant cases as well, just coming through the pipe. In terms of consular processing, I think that's going to be the next big issue. Once they lose in federal courts here in the States, my guess is they're going to just start trying to deny everything that they possibly can at the consulates, relying on the doctrine of consular non-reviewability, that you can't sue the consulate. If that happens, it's going to be really ugly right up front. I think it's going to be ugly right up front, and a whole bunch of people are going to get denials. Then all of a sudden, courts will see what's happening. And the courts will see all of a sudden, you've lost all these issues at home. Now you're denying at the consular level based on these things we already said were illegal. And I think that doctrine of consular non-reviewability will be threatened and probably destroyed if the agency goes that route. If they try and use thuggish tactics like that and do something that's underhanded, they'll shoot themselves in the foot.
Interesting. We're living in interesting times.
Yeah. Yes, we are.
Well, thank you so much. Now, what are the best way that people could reach out to you, your email and any social media presence that you have?
Yeah, I have a blog and an email. My email address is on the blog as well, but it's just jdwasden@economic-immigration.com. And it's probably the best way to reach me. And I'm also on LinkedIn as well.
Awesome. I'll definitely have your information in the show notes. Jonathan, thank you so much for coming to talk with us today.
No trouble. Thanks for having me.